Yes, please.
May I please have listing of matter, Lordship, on Thursday, if possible, Lordship.
What matter?
19, read petition, Lordship.
No, this is not a regular bench. This is special DB only for some special matters. What is your case about?
My case regarding this order passed by the tribunal, Lordship, we are challenged in the year 9.
Pilot for withdrawal.
Withdrawal.
Yes.
Tomorrow.
Tomorrow.
Day after tomorrow. Day after.
Yes.
Daily link for motion item 1.
Lordship, in this matter, we were supposed to obtain instructions. Instructions are waited, Lordship.
Yes, instructions are awaited.
Yes.
Second week of July, third week of July,
Yes, Lord. Yes.
on the prayer of Mr. A. Varman and extending counsel, Home Department, Government of Assam. This matter stands adjourned and shall now be listed again in the third week of July, so as to enable her to obtain instruction. Mr. H.S. Circle and counsel for the petitioner is present.
Item 2.
May I please, the Lordship? Lordship, LCR was called for, and this in that LCR has been received. My lord, matter may be posted for hearing, my lord.
So, should we post it for hearing?
Issue rule and post it for hearing, Lordship.
At Mr. S. Siddharth, Land Council, hearing for the petitioner also, but Ms. A. Varman and Attorney Council, Home Department, Government of Assam, Mr. K. Gogoi, Leonard, CGC, appearing for the Union of India, Mr. P. Sharma, and D. Assam, appearing for the state, and Mr. H. Kuli, and Standing Council, ECI. First up, the LCR as called for by this court has been received. After going through the LCR, we are of the view that the matter will require full-length consideration. As such, issue rule returnable in 6 months. Since the parties are already represented, no further notice is required to be sent in this case. Is this case hearing individual courts by tagging the LCR? Interim order passed earlier to continue.
Item 3.
My lord, in this case also LCR was called for, same, my lord. Yeah,
Same order, Lordship.
yes.
Item 4. Item 4.
Yes, who is appearing in this case? But cool, nahi. But without hearing, none appears to the parties when this matter is called. There is the order dated 22/5/2024, which goes to show that the Assam police is reluctant to accept the amount of rupees 20,000 involved under the circumstances. This court will have to consider issuing a direction, issuing appropriate direction or appropriation of the said amount in proper head. However, such an order cannot be passed in the absence of party to vote their sides. Such, this matter stands adjourned for 4 weeks.
Please matter 30, 39, 54. Possible for the two.
I am appearing in 42.
39 to 54.
I am appearing in 42 and 43. 42 to card. 42 and 43. These, as far as the causes of the Hindi teachers as well as the Arabic teachers in an upper primary school.
Forty-two and 43. Yes.
If you are not, you will please to take up the 2011 by the Act first, madam. 2011 Act. Section 4.
Yes.
The services of the employees of all eligible venture education institutions under Section 3 shall be deemed to have been provincialized on the date of coming into force of this Act, and they shall become employees of the state government with effect from that date, provided such institutions have completed at least 7 years of imparting education from the date of affiliation, recognition, concurrence, or permission, as the case may be, as of the date of coming into force of this Act. Now, subsection 2 of section 4, it says that the number of employees in both teaching and non-teaching cadre in each of the venture educational institutions, services of whom are provincialized or to be provincialized under this Act, shall not exceed as specified in the schedule appended to this Act. There was a limiting clause herein. Your Lordship, please to see the schedule.
Yes.
Down below, upper primary school. Has your Lordship got it? Madam?
Yeah.
Down below. Last but one,
Yes.
LP school and upper primary school. Headmaster, assistant teacher, graduate, intermediate teacher, science and mathematics, 1. Hindi teacher in the rank of assistant teacher, 1. Arabic teacher, 1. Assamese language teacher for non-Assamese medium schools, grade 4 staff, 1. This has been limited, and your Lordship needs to see the proviso to subsection 2 provided that where the number of employees serving in the venture education institution exceeds the number specified in the schedule, the provincialization of the services of employees shall be on the basis of seniority in the respective category of the concerned educational institution. That means if there is a 2 teachers serving in the school, only 1 teacher has to be provincialized. Now that was challenged in the earlier round of litigation. 2016, 5 GLT page 296. That was the subject matter of challenge.
Yes.
Paragraph 2, Your Lordship, will please. Paragraph 2.
Yes. Yes.
The petitioners in these cases, in substance, challenge the legal validity of the Assam Venture Education Institutions Provincialization of Services Act 2011, hereafter referred to as the Provincialization Act, and more particularly, Section 4.2 and Section 10.4, as also the schedule appended, whereby the state has fixed a cap on the number of employees whose services can be provincialized. Now, Your Lordship, please to see what is the finding of the court. Paragraph 33.
Yes.
When the arguments of the petitioners are analyzed, it is clear, paragraph 33, that the Provincialization Act has many legal failings, as it is not only discriminatory, but is also repugnant to the many aspects of the RTE and other central acts. Noticing the merit of the points raised by the petitioners, the government, in fact, has considered about the defects in the state act. The Educational Commissioner, in his affidavit, averred that the state has decided to bring in a fresh legislation to stimulate the process of provincialization by addressing the deficiencies in the present act. In such circumstances, the court can either strike down the offending legislation or target certain portions of the Provincialization Act to make the state legislation conform to the constitutional and legal requirements. Paragraph 34. What this litigation reveals, the total non-application of mind, it is all pervading in the state enactment. The discriminatory impact of Provincialization Act is found to be glaring here. In order to avoid impermissible discrimination, the classification must be founded on an intelligible differential which distinguishes people, persons, or things that are grouped together from others left out of the group. And also, the differential must have a rational relation to the object sought to be achieved by the statute in question. The petitioners here project that the teachers whose services are provincialized and those who have been left out are at par in all respects. In most cases, both categories have been rendering service in the school since inception and are similarly qualified as well as rendering similar duties. There is nothing in the face of the statute or in the surrounding circumstances to show any distinguishing factor. As also no rational relation of such differential with the object of the Act is discernible from the reading of the provision. In fact, the object of the Act is to provincialize the services of teachers in venture education institutions and prevent further growth of such institutions. However, the object of provincializing the services of the required teachers of the institution established bona fide negated by the enactment in the present shape. Then paragraph 38, my lord. When such substantial defects are perceived in a given context, the court can strike down only the offending provisions. However, when unconstitutionally is noticed in the major provisions, starting from the preamble to the schedule of the Provincialization Act, striking down the offending portion will practically decapacitate the 2011 Act. In other words, the statute itself will become inoperable, although the ultra-virus declaration is limited to some segments of the Act. The paragraph 39. Therefore, we feel that a piecemeal exercise will not serve the purpose, but all at the same time to suggest how the Provincialization Act should be reshaped would be including into the domain of the legislature. Moreover, amendment exercise might have to be preceded by a consultative process with all the stakeholders, and this is surely the responsibility of the state. That apart, it is certainly difficult to separate the bad from the good portion of the Provincialization Act. Under these circumstances, being convinced with the arguments of the petitioners, we declare the Assam so-and-so Act is constitutionally invalid. As the state has decided to bring in fresh legislation, considering the likelihood, then the scope was given to the state to bring in a fresh legislation. But the act was declared unconstitutionally invalid, being convinced with the arguments of the petitioners. That means the arguments of the petitioners were, apart from the question of repugnancy of the RTE Act and all these things, that if you want to provincialize the services of the teachers, the provincialization has a meaning. Provincialization has been defined in the Act. It's a present Act also, in the earlier Act also. Yeah. 2017 Act, well, it has been defined, provincialization.
Yes.
2P. In this book, whether if your lordship is holding the book,
Yes, yes.
then it is at page 104.
Mhm.
2P. Provincialization means taking over the liabilities of the payment of salaries, including dearness allowance, medical allowance, and such other allowances to the teachers and the tutors as admissible to the government servants of similar category, and gratuity, pension, leave encashment, etc. Under the existing rules to the government servants serving under the government of Assam. The provincialized school or provincialized college means an existing provincialized school or college or a venture education institution wherein the services of teachers and tutors are provincialized under this act. Therefore, provincialization means taking the services of the petitioners within the fold of the government. That is the purpose, object behind. Because the 2011 Act also, as well as 2017 Act, was promulgated to prevent mushroom growth of venture educational institutions, as well as to streamline and provincialize the services of the teachers. Can it be said, my lord, that the teachers who are serving can be left out on any count? Because that was the challenge to the earlier act also. And therein, the court has held that it cannot be done. Now, your lordship, please to see 2017 Act.
Just a minute. What is the definition of provincialization under the old Act, 2011 Act?
Possibly there is no definition.
I think provincialized school is only different.
Provincial school, only provincial school is there. Provincialized meaning is not there. স্কুল নয়, কি করছে?
But as per the 2011 Act also, the cutoff was 1/1/2006.
Yes, cutoff was 1/1/2006.
So whether under the previous litigation or this litigation, that is not under challenge. That cutoff of 1/1/2006, that you are agreeable.
That is because our cutoff date was previous to that date, prior to that date, 1/1/06. Or it was all in 2005. I am not aggrieved by that, but some persons are aggrieved.
The question is whether another subclassification is permissible
Yes,
amongst those institutions which were, although before 1/1/2006, some got permission belatedly, but with retrospective effect,
yes.
and others got the permission prior to 1/1/2006. That is the core
That
controversy.
is the code in some cases. But in our cases, all the cases, my lord, all the schools were provincialized before 2005, 2006. It was all in 2005, recognized, and permission was granted. Now, section 2017 Act, section 3 remains that as a challenge. Section 3, first we also may see. Section 3 of the 2017 Act. Subject to the provisions of section Article 30 of the Constitution of India, the following categories of venture education institutions shall be eligible for being considered for provincialization of the services of their teachers and tutors. This is, therefore, the following are the conditions for eligibility of a venture education institution to come within the fold of provincialization. Supposing 1, 2, 3, 4, all these are conditions precedent for an educational institution to come within the fold of provincialization. Now, your Lordship, please to see clause 11.
Yes.
In case of clause 11, in case of venture upper primary school, I have, my lord, in the definition section, upper primary school includes upper middle school madrasa as well as middle English schools also. In case of venture upper primary school, there shall be minimum 3 teachers or tutors, at least 1 teacher each for science, mathematics, social studies, and languages. If we stop here, this appears to be a condition precedent that each school must have minimum 3 teachers of these subjects. Apart from other subjects, we are not concerned. These subjects, the teachers in these subjects must remain. Therefore, the school will be, or the institution will become eligible. But reading the proviso, it appears to be a substantive provision. Provided that for additional posts, it shall be considered in accordance with the norms and standards stipulated in the schedule under section 19 and 25 of the Right of Children to Free and Compulsory Education Act 2009. Provided that for additional posts,
Yes.
it seems, my lord, although it is couched in the section 3, laying down the conditions precedent for a venture education institution to become eligible, if they fulfill those conditions. But this section, clause 11, appears to be a substantive provision reading the proviso. Proviso says, for additional posts, it shall be considered in accordance with the norms and standards stipulated in the schedule under this section 19 and 25 of the right of children to free and compulsory education. 19 and 25. Additional post means these three teachers will be provincialized. And for additional post, for any additional post, it should be in accordance with the RTE Act, scheduled to the RTE Act. This is what in the affidavit, counter affidavit, I have the counter affidavit filed in 3481. 3481, 2018. I was given a copy of the same, and therefore page 9, paragraph 11G. Has the Lordship got it?
Yes.
Paragraph G, 11G. This is 11G. As per section 3.1.11 of in the case of venture upper primary school, there must be 3 minimum teachers or tutors, at least one each for science and mathematics, social studies, languages, and if there is more than 3 teachers or tutors, the requirement of those additional teachers or tutors, whether it is in conformity with the schedule as per section 19 and 25 of the RTE Act, be it mentioned herein that the existence of minimum 3 teachers or tutors in a venture upper primary school, out of which at least one for each subject, science and mathematics, social science, languages, are the precondition for the venture institutions to qualify for provincialization of services of their teachers or tutors. As after coming into force of the RTE Act, it is mandatory for all schools imparting primary education to have these teachers. It is correct to have this. However, for any additional teacher, more than 3, next line, would be as per enrollment of students so as to maintain PTR in conformity with the schedule to the RTE Act. That is the 3 teachers will be only provincialized. And for others, additional posts, if any, that should be in accordance with the RTE Act. Now, your Lordship please to see the RTE Act. (19 and 25). Nineteen clause subsection 1, subsection 1, section 19, subsection 1. no school shall be established or recognized under section 18 unless it fulfills the norms and standards specified in the schedule. And if it does not fulfill those standards, then within a period of 3 years, it has to maintain it. It has to take steps for in conformity with the RTE Act. Then paragraph section 25, people-teacher ratio. Within 3 years from the date of commencement of this act, the appropriate government and the local authority shall ensure that people-teacher ratio as specified in the schedule is maintained in each school. Now, the schedule. Your Lordship, please to see the schedule. Number 2. No, number 1B. The schedule, it says, see section 19 and 25, norms and standards for a school.
Yes.
Your Lordship, please to see 1A is for first class to 5th class, that is lower primary, then class 6th class to 8th class, that is the upper primary. At least one teacher per class, so that there shall be at least one teacher, each for science and mathematics, social studies, languages. At least one teacher per class, so that there shall be at least one teacher, each for science, mathematics, social studies, and languages. At least one teacher for every 35 children. That is 1:35. PTR, people-teacher ratio. But this is not a fixed formula, because the less the number of students, the better. It may be 1:10, 1:16, instead of 1:35. Others are not required herein. At least one teacher per class. 6, 7, 8 assumes, RTE Act assumes that 3 classes are there. It does not take into consideration the sections in a class. Supposing there are 2 sections in a class, class 5, 6, class 7, 6, 7, 8 does not have anything. Then one teacher per class, that means there should be more teachers.
So, Mr. Das, we have to ask one question here. You don't think this is a good idea, so you want it to be struck down. Is that the?
No. I say that it says about the minimum, at least one teacher per class. It does not say
Right, it's
there
a
is no
bad-
debarring
it's a-
clause.
It's a bad policy. It's a very bad policy. But can the court strike it down on that?
No, I am not asking. But there is no debarring clause hearing that you cannot have more teachers for provincialization.
Mhm.
That if the Arabic and Hindi teachers are provincialized,
Hmm.
that will be in accord with the RTE Act. 1:35 is not there. is a rigid formula.
So 311 also says it will be in accordance with RTE Act. That's what 311 says. 311 says that only. For additional teachers, it will be in accordance with the
RTE Act means RTE Act means it says that 1:35. If there is more than 35, then additional teacher will be taken.
So according to you, 35 should go.
1:35 is not that there can be more teachers.
No, but
PTR,
who will
PTR.
decide that? Who will decide that?
Well,
There can
it
be
is-
more teachers. Who will decide that? Is it to be decided by the state or by the court?
The state.
The state has decided. We are asking you one thing, that you are challenging the provision of a statute,
Yes.
correct? A counsel of your eminence need not be pointed out. What are the limited grounds on which?
Yes, repeated grounds are
Yes.
3. Now it is one more.
Bad provision in the statute is not a ground
No.
to strike it out.
Either it should be legislative incompetence or constitutional infirmity, or it is manifestly arbitrary.
That's right.
3 grounds.
Yes. So they say that minimum this will be there, but for additional, you will have to follow the pattern laid down in the RTE Act schedule. According to it, it's a completely arbitrary clause.
That clause is arbitrary. That clause 11.
Why is it so?
Because, well, you are not pleased to see. Two 2021, 17 SCC, page 1. Oh, opinion,
Mr. Gogoi, who is arguing for the state?
Under the advanced lordship, in the elementary and secondary part, and I will assist in regarding higher education part also.
No,
Be ready after this.
Lordship.
21, 17.
No, but this statute and the challenge AG is not coming.
So it's the same lordship. There, as occasion lordship, we have informed.
Inform?
Last occasion lordship, we have informed before your lordship that IG will not available today lordship. But lordship has indicated that we have to file written agreement otherwise.
17 is
We'll record it, what
page 1.
Lordship.
station is understandable, but
Lordship.
this is a special DB.
Lordship.
We can't ask why he is out of station, but
Lordship.
that doesn't mean we have to wait.
Lordship.
So we'll note that he has not appeared.
Otherwise, lordship, he has to agree.
Hmm?
As per our instructions, lordship, he says that he will argue the case, but lordship has indicated that no adjournment should be given. And
No,
lordship,
no adjournment because it is a special bench,
lordship,
not otherwise. We don't
Lordship.
have any problem in giving adjournment,
Lordship,
but
Lordship.
the only matters are these matters.
and
only.
if lordship accommodate, then lordship, day after tomorrow, he will be, even tomorrow also he will be available, but the bench is not available tomorrow, lordship.
Day after tomorrow is available.
Lordship, he will be available. Only faster. Day after tomorrow.
No, you please find out if day after tomorrow is available, then we can think about it. But
Lordship,
we would like to close it before vacation.
lordship. Lordship,
These are very serious issues
lordship.
to find out.
Lordship.
We would like to accommodate the
Lordship,
learned
Lordship,
AG. There is no
Lordship.
difficulty with that.
Lordship,
But the problem is it can't be in a very vague manner.
lordship.
He's not available, so whenever he is available, it can't
Lordship.
be like that. There's a definite prayer made, we can note and maybe consider,
Lordship.
but you find out.
Lordship.
We appreciate there can be some personal difficulty
Lordship.
that we
Lordship.
appreciate, but it has to be definite, can't be vague.
Lordship.
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 We have been hearing this matter last week also, this week. Now it has to come to an end. We have to write out a judgment. Therefore, we'll not push it beyond vacation.
Yes.
Whatever be the. That is. Yes. listen.
Perhaps 2021-17 SCC.
Hmm.
Copy line, huh?
2021-17 is.
Page 1, paragraph 40. It is said about the people-teacher ratio. বই দেখালো যে? Oh,
2021-17 SCC page.
Page 1, paragraph 40.
Yes.
I am reading it, my lord, slowly. Needless to observe that the norms and standards, in particular regarding the people-teacher ratio, specified in the schedule to the 2009 Act, are only to delineate the minimum benchmark. It is open to the state government, being the appropriate government, to provide for a higher benchmark for ensuring imparting of quality education by the schools within its jurisdiction. Because quality, the RTE Act is child-centric, is not school-centric. And the education is free and compulsory. The government cannot say that we don't have financial, we have the financial crunch, therefore we cannot do. It is to garner the resources of its own and to provide free and compulsory. Compulsory in the sense that it should ensure that every parent sends their words to the schools. In that sense, people-teacher ratio is not a hard and fast rule as such. 1:35, as is said, and so far as the northeastern states are concerned, it is less than that. I have given in my note, my lord, page page 4. B, last below. The ratio of PTR 1:35 as provided in the schedule to the RTE Act is the minimum benchmark. The less the number of students per teacher, the better. It is open to the state government to provide further. It may be stated that in the northeastern states, the PTR as follows: Mizoram 1:13, Sikkim 1:10, Arunachal Pradesh 1:15, Meghalaya 1:21, Manipur 1:16, Nagaland 1:14, Tripura 1:20, and Assam 1:21, while it stands at 1:28 for the nation. This is the report is released by the Union Education Ministry for the year 2021-22. The government is saying that 1:35 is a hard and fast rule. We have to follow it. In that case, it is
No,
not.
they are not saying it is a hard and fast rule. Sorry, that argument. They are saying this is the procedure we'll adopt.
Yes,
They're not saying 2009 RTE schedule is a hard and fast rule. There is a difference between the two. Hard and fast, they are not saying. They're only saying that we have decided to follow this. This is their decision.
yes, their decision
Yes.
means, mother, that if there is 1:35 for additional post, if there is more than,
Mr. Das, let us have clarity on some very key issues. Your arguments, you refer to that 2021-17 SCC, etc., to say that this schedule, this ratio PTR ratio is not hard and fast. That's all right. It's not hard and fast. We know it is not hard and fast. But the government says for additional posts, this is the norm we will follow. They have
Yes.
decided to follow this norm. That norm is based on a statutory provision which brings into effect the RTE Act 2009. The question is this decision arbitrary, warranting a striking down of the provision, or is it a matter of policy of the state which they have expressed in the form of 311? That's the only question we'll answer
Yes.
here. Nothing more, nothing less.
Yes.
If the answer is the second one, so 2 paragraphs on this clause, nothing more than that is required. There is no question of hard and fast. There is no need.
Yes.
Yes, there is no question.
Therefore, I want to humbly submit that additionally 2 teachers, my lord, the language says of the Provincialization Act, if your lordship please to see it. In case of benefit, there shall be minimum 3
we
teachers.
appreciate the predicament of your client. If this embargo is released, then everybody can come in. That's the whole idea. Let's be
No, only teachers in the, yes,
That's the whole thing. There's nothing to say no to this. Somehow get rid of this embargo so that everybody can come in.
yes, that is the purpose of the act itself.
And that is the purpose of the petition also, to
Yes.
remove it. But whether that is a ground to strike down a statute, that is the only thing the court will consider.
This becomes arbitrary then, manifestly arbitrary.
To follow a prescription of a statute according to is arbitrary.
Prescription of a statute does not say so. That is what I am trying to submit before your lordship. 1:35, that what they mean to say, that they will follow 1:35.
So according to you, what should they follow? What should they follow? Not, let us forget, RT they should not follow.
Yes.
What should they follow?
No. If the teachers of Arabic and Hindi are provincialized, it may come down to 1:16. But that will not be against the RTE Act. It may come down to 1:16. It may not be 1:35.
Correct.
It may be come down to 1:16, almost 1:20. But that is within the RTE Act, it should be. That is my submission. And your lordship has seen, but in 2011 Act also, 1 teacher of Hindi and 1 teacher of Arabic was there. 1 teacher, 1 teacher. It was there.
So now Hindi and Arabic they
Are completely obliterated. Hindi is a national language under the 3 language formula. It is a must for class up to class 8. 9, 10, 11, 12, it is optional. And Arabic is a compulsory subject in ME madrasas, Middle English School, madrasas. These are not the madrasas where theological subjects are only taught. Here, apart from those core subjects, namely MIL, English, Science, Mathematics, and Social Studies, Hindi, Arabic is taught as a compulsory language. Now, therefore, I would humbly submit that if Arabic and Hindi teachers are brought in, that will not go against the RTE Act. In that sense, view of the matter, that this clause is arbitrary, as manifestly arbitrary. No. And factually, my lord, our, in all these schools, our enrollment are more than 100.
All right, we have noted, yes. So, so in essence, your argument is that when these venture schools were operating, they had these different
Yes,
subjects, teachers were there. Then the state provincializes service of some teachers, takes over the school, but comes up with a criteria to omit subjects such as Hindi and Arabic in a manner that the teachers teaching these subjects, they are dropped from the process
Yes.
of provincialization for all times to come. So according to you, this creates a classification, a discrimination
yes.
between teachers
Who are
Two
serving,
who
who have been
different categories.
provincialized and who have been left out.
And this has been sought to be done in the garb of schedule of RTE Act 2009,
Yes,
which according to you does not create any such binding embargo on the state.
yes, yes.
That is your argument?
Yes, yes, yes.
Have we
that-
missed out on anything?
No, no, no. Yes. And another thing, my lord, your lordship has seen section 3. The recognition before that date is a condition precedent for becoming eligibility.
No, that's right. That's not under challenge.
But for the purpose of recognition, what is the requirement? Your lordship, please to see, my lord, my petition 5416 on document I wrote. It is available in both the petitions 43, 45, 5416, 43.
Page number 43.
43.
Yes.
I could lay my hands on this issue in inviting a reference to the subject quoted above. I have the honor to state the recognition of ME schools are accorded as per staff pattern shown in the minutes of the state level committee to consider the permission, recognition, upgradation, and concurrence of education institutions. Staffing pattern of recognized middle schools are as follows. 1 teacher per class, including headmaster. The qualification of headmaster should be at least graduate. In case of assistant teacher, minimum qualification should be at least SSC pass. There should be one science graduate teacher to teach science and mathematics. C, one Hindi teacher with qualification, HSLC pass and Hindi Bishrat Bobid for Hindi non-Hindi medium schools. For Hindi medium schools, there should be one regional language teacher with minimum of so and so. Then D, E, in case of ME madrasa, one Arabic teacher. In case of non-Assamese medium schools, one Assamese language teacher. In case of ME madrasa, one Arabic teacher. Well, Hindi teacher and Arabic teacher were must for the purpose of granting recognition. If that be so, it is inconceivable that for the purpose of provincialization, you can omit this person. On this ground also, it seems to be very arbitrary. For the purpose of recognition, you require this stopping pattern like this. And that is why possibly in 2011 of the Act, Hindi and Arabic teachers are also included. Now it is inconceivable that for the purpose of provincialization of the teachers, the abode object being to streamline and omit further growth of mushroom growth of venture schools, you can omit these two persons, the teachers of these two categories. I am not saying, my lord, how many teachers will be taken. I am taking these two subjects are a must. Yes. I want to place before your lordship another document, my lord. This is in my additional affidavit in case 5416 dated 21/2/2022. Additional affidavit.
Yes, you're referring to?
My lord, Annexure 2, huh? 2, page 12. And the additional affidavit. Page 12. This is a letter from the director to the secretary after provincialization.
Yes. Hello? Yes.
Well, paragraph 1. Middle below. This is first middle portion. In this regard, it is stated that in UP schools, upper primary schools, from class 6 to class 8, there are more than one language to be taught. And being the national language, Hindi is a compulsory subject in UP schools. And also Arabic is a compulsory subject in MEM. MEM means madrasas. ME madrasas. Without having Hindi teacher or tutor in UP schools, as well as Arabic teacher in MEM, the students will be deprived from learning the above compulsory subjects. On the other hand, without having requisite qualification in Hindi and Arabic subjects, no other tutor can teach the same subject. It is also mentioned that at the time of recognition of the ME school, MEM Hindi and Arabic teacher were allowed to include into the staffing pattern of the same school. If the RTE Act is child-centric, it is not school-centric, and if it is free and compulsory,
Is Arabic a scheduled language in India? Is it a part of the scheduled languages?
was possibly not.
Huh?
I don't know. A
See the
constitution.
Constitution.
Constitution. 8 scheduled. Eight scheduled के तो था. Assamese, Bengali, Bengali, Hindi. No, it is not there. It is not a scheduled language.
But Hindi is.
Hindi is. Punjabi, Sanskrit, Sanskrit, Hindi.
Yes, sir.
Urdu is there.
But
Last
Urdu and
year.
Arabic are two different things.
Different.
Arabic and Urdu are two different.
No, Hindi and Urdu are almost similar.
So is the state bound to, we can understand Hindi being a 8th scheduled language. But Arabic is not an 8th scheduled language.
That's correct. But it is in ME Madrasa. ME means Middle English School. And ME Madrasa means where originally, where apart from the other subjects, as are taught in upper primary schools, Arabic language is taught as a compulsory subject because it is madrasa. And the state has recognized it. And for the purpose of recognition of a MEM as the upper primary schools, it is required. The stopping point are required.
So you are saying that ME madrasa are recognized by the state
Yes,
and Arabic is a subject in ME madrasa.
ME Madrasa. only.
But someone who teaches Arabic will never be provincialized
Yes,
because of this act.
yes. That is. And the term language as used in clause 11 means, my lord, English and MIL. This can be deciphered from other provisions of the Act. Namely, clause 8, in case of venture ME school, there must be one science teacher or tutor to teach science and mathematics. In case of venture high school, clause 8, my lord, of 2017 Act.
All right, so that's your argument.
Yes, my lord. So taking a cue from the 2016, 2011 Act that was challenged and the judgment of the Honorable High Court, that you cannot put a cap. That was the finding. You cannot put a cap on the number of teachers to be provincialized. That will go to favor of
So everybody has to be provincialized.
the teachers who are working there.
And state is bound to,
That is
Allocate
the
this.
finding of the court below.
no,
That
no,
is the
but what
finding
do you
of the
say
High Court.
about it? We are not, the earlier act is gone.
Other case gone.
So we are looking at the present act.
Yes,
So are you saying that state is bound to allocate the resources? Everybody who was in the venture.
I don't say
Hmm.
that to that extent, but the court has said to that extent.
No, what do you say?
I say that leaving out the two subjects is arbitrary. Hindi and Arabic in MEM. MEM when it means
In madrasa.
ME Madrasa. These are the two.
Plus nine RT. 10, 11 or 8, it could have gone on this night. মানে provincial শব্দটা তো নাই ছিল তো খালি এগুলা রেগুলেট করলে
rule to बनाए so that promotion के headmaster validation को institute से education করে এইগুলোকে চলে schools where the pensions they are as from those provinces এটা province করে এটা subject গুলা এই যে
even not provincial
this provincial is under the previous
provincial মানে সরকারি ডিসিশন
elementary provincialization of service and rules and reality and elementary so these are under education education repeal করে services elementary state provincial তো এই provincial আসলে এখানে সিম্পল এডিশন আছে এলিমেন্টারি ওখানে মিডিল ইংলিশ আর তিন তো এমন বাচ্চারা মনে রাখতে পারছে এটাকে সেকেন্ডারি এডুকেশন এজ এ হোল ম্যান্ডেট অলমোস্ট রিফিলে করেছে 2003 তো এখানে সার্কুলার রেগুলার ইজ অফ কেতিয়াও মাস করে টু ডিভেন্স ক্রিয়েশন আছে টিচার অর this is the history even without even colleges initially actually basic grant in 8 get a rule and we don't give some deficit and anything we can take it all college teachers will to provide is over relating to college thereafter after that it's a junior colleges we have metro upon higher secondary level
historical age of yes Mr. Das anything else
Well, this is the submission, but I will cite some cases. Your Lordship take note of it. I will not read it. But one, except one.
yes
My Lord, your Lordship has seen, my Lord, 2016 5 GLT. 34, 33, 34, 2016 5 GLT. I have given in my chart
yes
written notes, my Lord. Only one case I'll read. 17-9 SCC 1. arbitrariness is the ground of challenge. Now,
2017,
9 SCC, page 1. Therein, the earlier all cases have been considered. And your Lordship, please to consider that, remember that Mardia Chemicals case, in which it was set down that for filing an appeal under the certain provisions of the Act, particular amount to be deposited. That was deemed to be arbitrary. That was held to be arbitrary.
that is surfaces.
Services Act. That was deemed to be held to be arbitrary, and it was set aside. There are
Mardia
other
Chemicals-
cases also.
Mardia Chemicals upholds surfacing. Surfacing was under challenge.
আমার
in
খাতাটা
Mardia.
ঠিক। খাতাটা। আমার খাতাটা কই? খাতাটা। হ্যাঁ, খাতাটা। SSC মধ্যে আছে। ঠিক আছে।
তাতে সেই
Yes.
এটা opinion এই opposite to অকল হেৰি কৰিছে।
Seventeen, 9 SCC, page 1, paragraph 95, 101, 104. Paragraph 95. On a reading of this judgment in natural resources case, allocation case, it is clear that this court did not read McDowell as being an authority for the proposition that legislation can never be struck down as being arbitrary. In the McDowell's case, 96, 3 STC, State of Andhra Pradesh versus McDowell, it was held, two-judge bench had held that a legislation can be turned down can be struck down only on two grounds: legislative incompetence or constitutional violations. In fact, my lord, Noriman the judgment which stated that legislation can be struck down on the ground that is hundred and one, 104. Hundred and one, madam. 104. This is the case of triple talak's case, madam. Herein, the question of arbitrariness as a ground of setting aside a legislation has been considered, and it is given a third ground. Okay. 12-6 of this. 12-6. 12-6. देखिए। You would know. 2012, I'll cite my note, 2012, 6 SCC, page 1. Paragraph 6, 7, and 28. Six, 7, and 28, madam. In 28, Article 21A, interrelation between this act and Article 21A has been brought in. Madam, 86 টা দেখুন। 86 টা। 8. 1. Interrelation করুন। সবাই তো খুবই
Yes, we are human, but,
Two thousand three, necessary.
Yes, yes, yes.
But the next case, but 2008, 6 SSC, page 1. It's a long judgment. Para 420.
information.
This will be at 2008, 6 SSC, page 1, paragraph 420. That will be available at page 647. 420, 435, and 490.
Para numbers,
420, 435, and 490. Those will be available at page 467, 647. I'm sorry. 650 and 663. Don't see it. Right. Right, right. Seven one to the 7-1. Seven three two.
yes.
420, 435, 490. No, I don't. 14, 18, 14, 8. Unity. Well, these are my humble submissions before Lordship. I would submit that if the object of the act is to streamline and provincialize the teachers, and because the provincialization means a definite, it has been given a definition. It means by not taking the opportunity of bringing into the government fold of all the teachers. And if the object is for the purpose of stalling the further growth of venture education institutions, it is high time to permissible. It is impermissible to leave out some teachers on this ground or that ground. That will be arbitrary. And I have given a written note, my lord, your lordship will please to see it.
Yes,
I will be deeply obliged to your lordship.
yes.
Sixteen.
One of the groups are over. Hello. Group is left, huh?
In group 13, my lord, I have item number 39, my lord. Actually, I have challenged 3110, my lord, but it is strongly shown 3111. Item 39, my lord. Therefore,
You are in which group?
group 13, item number 13, my lord. 39.
So it will be with group 16.
It will be a separate group, my lord. Maybe taken as last group, my lord.
Only one is left. We have finished everything.
So after that, my lord, item 39.
Only the group 20 is. What is group 27? Who's there in group 27?
Group 16.
We finished all these things. No, it's over means over. No. None appears in group 16.
Right.
Not there. Where is Mr. Chaudhary? He was supposed to argue. Mr. K.N. Chaudhary? Otherwise, we'll close petitioner's argument and move on to state.
The AG Lordship accommodation, my lord, the AG is not here today. If we have time on Wednesday, my lord, we can address the court, my lord. Today he's out of station, my lord. On Friday, I had said today he's out of station. Tomorrow he's here almost the whole day, and Wednesday, first half he's here. Tomorrow the bench is not here. So little accommodation, my lord. Wednesday we'll try to sum up as much as we can, my lord. To some extent, my lord, we have prepared, but the AG has to address is one of the, my lord, because
All right,
we have
take
understood.
your seat. We'll see what can be done.
My lord, in item number 61, my lord,
Hmm.
group 16, I am
in item number 61, madam.
Hmm.
Madam, here this petitioner, the craft teacher, madam.
No, yesterday, nobody appeared.
Sorry, madam, that is. confusing, madam.
No, this can't happen in this manner.
No, sir.
We have to, you give your written submission. We will not hear it.
I'll give.
Whatever was called yesterday, none appeared, that's over. You give your written note. You have to be present when your matter is called.
Sorry, madam. No, I was a little confused, madam, because seeing the item number, madam.
Faster.
Also in item 62, I have filed my return argument.
Item?
In item number 62, group 17, I have filed my return argument.
Madam, last time I note I will file, madam. Item number 61.
Yes, Mr. Chaudhary.
Item 5.
May it please, your lordship.
Yes.
My lord, I made some preliminary arguments. Let me do it comprehensively now. Now, first I'll address on the craft teachers. I have given a little background of the facts in this case. That the petitioners are working as craft teacher in different venture high school, high madras of different district for the last 12 to 26 years. The petitioners are all diploma holder of Industrial Training Institute from different vocational institutes, relevant environments at Para 2. That in the year 2011, the state government enacted the Assam Venture Educational Provincialization of Service Act 2011 in order to provincialize the services of teaching and non-teaching staff of venture education institution. The petitioners in the instant case writ petition were eligible for provincialization as they fulfill the criteria laid down by the Act of 2011 as amended. Inasmuch as their respective high schools, madrasas were also recognized by the state government as per the norms laid down in so and so. As a matter of fact, names of the petitioners were recommended for provincialization by the authorities specified in the Act. Acting on the recommendation referred to above, services of approximately 42,000 employees were provincialized under the scheme of Act of 2011 in the initial phase of provincialization. Services of another 32,000 employees, which includes the petitioners, were also recommended for provincialization, could not be provincialized, as in the meantime, this Honorable Court in WPC number so and so struck down the Act so and so as unconstitutional. Following striking down of the Act of 2011, the state legislature enacted the Assam Educational so and so Act of 2017. By means of the present petition, the petitioners seek to challenge the legality and constitutional validity of the Act so and so in general, and section so and so of the Act, amongst others, the following grounds. Now, the factual background is, my lord, pursuant to the earlier Act, 42,000 and odd were provincialized. Our cases were also recommended. Idea is, in the phased manner, our to be done, because of therefore the intervening development took place. Now, let me briefly indicate, my lord, the facts and the grounds on which then I'll come to my submission.
Yes.
For that, section 4, read with section 2H of the repealed Act, creates a living provision by virtue of which services of the petitioners who are otherwise eligible were deemed to have been provincialized by operation of law. The said right of deemed provincialization accrued to the petitioners cannot be taken away by the impugned Act. In other words, petitioners who acquired the vested right of deemed provincialization under section so and so, read with so and so, cannot be taken away by the Act of so and so. Section 4 and 2H is extracted below. By now, Lordship has read it. Now, please come to 2. For that, it is a well-settled proposition of law that when a statute creates a legal fiction, it is the duty of the court to give effect to such legal fiction. So these are the provisions and the decision. That the petitioner submit that Act of 2017 is not a validating legislation, hence the provisions thereof cannot be made to apply retrospectively. The vested right of the petitioners to have their services provincialized is sought to be taken away by prescription of conditions which are expressly arbitrary and discriminatory. The proposition that retrospective enactment cannot take away vested right and enactments must be reasonable and consistent with Article 14 and 16 is fairly well settled. So we're relying on these authorities, my lord. Then what is important is 5, which I will argue in details at page 4. That by operation of Section C of the Assam General Clauses Act, read with Section 24 of the Act of 17, the right of petitioners to be considered for provincialization of their services have been saved. In this regard, petitioners seek to rely upon the decision of the apex court in so and so. It will be noticed from the Act of 2017 that there is no intention to take away the vested right of consideration for provincialization conferred by the Act of 2011. The said intention can be gathered from Section 4.1 of the Act of 2017 itself. However, the said intent is qualified by Section 4.6, which is nothing but an additional requirement. Notwithstanding Section 4.2.4, no intention to take away the vested right in terms of Section 6C, read with 24 of the Act is discernible to deny to the petitioners their vested right of deemed provincialization. The effect of Clause C2E of Section 6 of the General Clauses Act is to prevent the obliteration of a statute in spite of its repeal, to keep intact rights acquired or accrued and liabilities incurred during its operation, and permit continuance or institution of any legal proceedings or recourse to any remedy which may have been available before the repeal of the enforcement of such right and liabilities. The distinction between what is and what is not right, preserved save by Section 6, is often subtle and yet it exists in law. Therefore, what is unaffected by repeal of a statute is a right acquired or accrued under it and not mere hope or expectation or liberty to apply for acquiring a right. So these are the propositions I'll rely. In the instant case, by virtue of Section 4, read with Section 2H of the Repealed Act, right of deemed provincialization which accrued to the petitioner stands safe. The Honorable Apex Court in so-and-so held that if a right is created by a statute, is of an enduring character and is vested in person, the said right cannot be taken away because statute by which it was created is repealed. This Honorable Court would appreciate the right of deemed provincialization which the petitioners are claiming is not a mere abstract right. Having regard to the facts of the case, the Court of Appeal in so-and-so held that in spite of repeal of Section 11, the tenant had acquired the right to claim compensation as notice to quit was given to him when Section 11 of the old Act was in operation. Similarly, in the instant case, following provincialization of 42,000 employees in the first phase under the Act of 2011, the case of remaining 32,000 employees of the venture educational institutions, which include the present petitioners, were recommended by the competent authority, and in normal circumstances, their services would have been provincialized in the second phase, but for the intervening development. In Gajraj Singh, the Honorable Apex Court observed that some positive act is required to be done for the right to accrue under an enactment which is repealed. Similar view has been taken by the Honorable Apex Court in Air so-and-so. The principles enunciated in the judgment shows that when a right accrues to a party under the Repealed Act, it is not necessary that for the right to accrue, legal proceeding must be pending when the Act comes into force. That apart, section 24 of the Act of 2014 is somewhat incongruous inasmuch as the said provision far outweighs the ambit and purport of a repeal and saving provision, which perhaps requires reading down to make it consistent with section 6 of the General Clauses Act. My lord, end of the day,
General Clauses Act.
it is section 6, which has to be, but the provision created by any legislature has to be compliant with section 6. Now, my lord, here in this case, what I will try to emphasize is, now, whether there is a repealing or saving clause or not, it is basically section 6 which determines the rights and obligation of the parties. And
Okay,
Supreme,
Mr. Chaudhary, since we are in section 6.
yes,
Can we request you to please read section?
yes, my lord. Where this act or any central act or regulation made after commencement of this act repeals any enactment hitherto made or hereinafter to be made, then unless a different intention appears, the repeal shall not revive anything not in force or existing at the time at which the repeal takes effect, affect the previous operation
Just a
of.
moment, what we are saying is, section 6 prima facie does not include a state act?
Not necessarily, my
No,
lord.
no, but the.
But yes, by purport of the language of the pre-constitutional law, even if your lordship will kindly have the constitution, I mean constitution don't have now. If your lordship will kindly come to 367.
So anything to show that 6 will cover even
Yes,
state law?
so we have our state act. In this case, we have our state act also. Same parameter, my lord. Assam Act is 1917. Same provision. My lord, for guidance, it would be appropriate to even in Constitution, General Clauses Act has been adopted. If your lordship will kindly come to section 367, Constitution 20%.
Article 367.
Yes.
So state economy, state.
367, 20 কিবা আছিল নেকি? Uh-huh. 367, unless the context otherwise requires, General Clauses Act 1897 shall, subject to any adaptation and modification that may be made herein under Article 372, apply for interpretation of this Constitution as it applies for interpretation of the Act of the Legislature of Dominion of India. Okay. And Assam General Clauses Act are also on the same line. Now I am on C. Affect any right, privilege, obligation or liability acquired, accrued, or incurred any enactment so repeal.
Yes.
So basically our case is the provision of deemed deemed provincialization that has to be given effect.
Right.
And
now,
I have brought 3 decisions of the Supreme Court.
we don't want to disturb your
Yes.
flow, but for a moment we have to interject. Would you now come to the last paragraph of the order passed by the division bench in the review petition?
Okay.
And tell us. what
Para
really-
19.
Yes.
Yes.
Go to R90. The only
I think it is 285. Yes. At page 303. Para 18 and 19 perhaps, my lord.
Yes, yes.
The state in their application have stated that the group they are concerned with are those who have retired and are drawing pension Another category who are now government employees and are receiving regular scale of pay, and people of the same class who have moved on in their career and in life. There are around 634 employees for whom vested rights are already created under 211 enactment. But through retrospective application of our 23rd September 16 judgment, they may not only lose their government job, but will also be disentitled to pension and salary. Moreover, the question of recovery of already disbursed salary and pension may emerge. The harsh impact of the retrospective application will be crippling for the already provincialized group, and their livelihood and in turn life itself will be adversely impacted. All such debilitating consequences will occur without any opportunity of hearing to this category. Many families dependent on earning of the provincialized staff are enjoying a measure of social and economic security, and they're all thrown, then they will be thrown to the street without any fault of their part. My Lord, with utmost respect at my command, I will respectfully submit this para 18 is absolutely uncalled for. Even if the act is struck down, the rights which have acquired will never be affected.
That's right. But
By principle of by application of two doctrines. My Lord, that doctrine of it. Anyway, nowadays I tend to forget.
no, that is all right. We are looking at it because we have to give due meaning to.
Yes,
That's why.
that's what I'm trying to say, my Lord.
Hmm.
Etu ki asile he je action to save hoye jay. Anyway, মানে action to ভুল হলেও anyway, so my Lord, the honorable, now
19,
let us come to the first judgment first.
19, para 19 now.
Yes,
Para 19.
okay. In the above circumstances, we are of the considered view that rights of the employees who have been benefited under this struck down statute can be taken care of by giving retrospective effect to the proposed legislation if the legislature so decides. Till then, it is ordered that services of the provincialized category and their status as government employees shall not be disturbed, and they will continue to receive all the benefits which they are getting under the Provincialized Act, since struck down by the judgment and the review. With this observation and direction, the matter stands disposed of.
Now, please pause for a moment. The reason why we are for the second time coming to this part, let us put it very clearly. When an act is struck down by the court, it becomes void ab initio.
Yes,
It is
as if
struck down,
it
was
never existed.
But the situation is different when the act is repealed and replaced by a new act by the legislature. There, the saving and repeal clauses have a completely different meaning. Correct? The legislature is within its authority and domain to specify what would be the effect of repulsion of the act and repealing of the act, and in what manner rights will be protected or affected. This, when read in the context of Section 6 of the General Clauses Act, the court can give a meaning. But when the act is struck down, as is the case in this case, maybe on a concession, but the act has been struck down. Here also the court says that the legislature will make a retrospective provision to save, and till such time the act is enacted, they will not be disturbed. Now, this interim protection, in our understanding, recedes into kind of irrelevance moment the act comes in. The act will now have to take over. On a closer reading of the provisions, we find that 2017 Act does not contain any provision retrospectively protecting the rights of those employees.
Or validating the appointments.
Validating their appointments. That provision is not there. Right. So the understanding could be that the court has protected, but the court's protection is only to this extent. It evaporates the moment the new act comes in. But the court says it will be for the legislature to make retrospective amendment, which in a way may be obviously the right approach. But the legislature has not done it. So forget the 35,000 who are now asking for regularization or provincialization. Another question which came to our mind is what has
What will happen
happened
to
to
this 43,000?
45,000 who has been, according to the state also, who have been provincialized. If their right is protected and they will continue as provincialized, which is the provision in the statute or which is the paragraph in the judgment which assures that? We have not been able to find that.
No, it's not there.
If it is not there, then what will be the consequence? Because we are going into we are deep diving into legal principles here. It is not a.
No,
this
I have
case
followed.
has
My lord,
anything-
my,
nothing
my,
to do with
my,
that.
my humble understanding is, I think we should, rather it is my submission. My lord, this para 18 and 19 in the review judgment. Now, because it is a judgment in review, therefore it merges with the earlier judgment.
Right.
So now this has to take over. Now, this judgment or the facts on which the judgment was rendered was something to do with the provincialization which has already happened. Now there are some directions by the Honorable Court, legality of which is not being questioned by anybody.
Mhm.
Therefore, let us not go into this, Miller.
No, Mr. Chaudhary, sorry, there is a problem here.
No,
The
there is, I'm
petitioners
trying to make a submission that there is no problem.
You make it.
Ah.
The basic argument is that of equality. Equality among the teachers whose services were provincialized,
My lord,
those were left out.
my lord, Supreme Court says that if savings or repealing provision is discriminatory, then also court can interfere. Apparently,
Then we have to proceed in that manner.
yes.
We cannot just brush aside this
No.
aspect.
No, what I'm trying to say,
Hmm.
well, for some reason nowadays I tend to forget the principle to validate whole time. Well, the legal principle
Is
is
it that age is catching up? Mr.
no,
Chaudhary?
maybe not. Nowadays, or maybe because of some other habits, it must have happened. Huh. Now, my lord, there is a principle. If a law is struck down, or even by the court or by the legislature,
Correct.
then the actions taken are saved.
Yes, there is a judgment of Supreme Court also on that. Hey, just 1 minute.
There is a doctrine, my lord.
There is a division bench judgment, Nandalal and Sons.
Make a doctrine to the state for the action.
This is Ranjan Gogoi and this Judge Jessica. Yes, no. Yeah, chairman as consumer road.
Basically, who say?
GST.
Supposing, my lord, a work order is issued by a particular officer. The officer is dismissed. The work order doesn't evaporate.
That's right.
That's the principle. It is not coming to my mind.
That's the
In legal principle,
But
in
here
administrative law, this has developed.
Here there are specific directions.
No, what therefore I'm saying is, my lord, it's true, my lord, if in a legal law, if in a judicial order, even if any aberrations has crept in also, unless that order is challenged, that will attain its finality.
That's right. So we are concerned about how to reconcile this.
Yes, the way of
the
way of reconciling is perhaps subject to correction, my lord.
Yes.
Perhaps this case has to be confined to the facts of the case whose services are provincialized. There is no dispute that there is a deeming provision in the Act. In that perspective, Lordship will have to proceed. Otherwise, my lord, there is no end to this problem. Because if your Lordship tries to solve this problem, I think new jurisprudence has to be written. At least, my lord, therefore yesterday, whole day I have GP Singh's book, my lord, I have read it wholly. I couldn't find any situation like this. Where?
All right.
Anyway, so my lord, my humble submission is, the moment there was, it should not have been the concern of the court regarding saving the appointments already made,
Correct.
merely because the law was held to be bad. If the law was held to be bad, it's bad. Henceforth, that law cannot be operated. Whatever had happened, that cannot be wiped out. That is the principle.
That is it.
So therefore, this para 19 was uncalled for. So an observation which is not consistent with the legal principles, that is not binding on any other person's matter. Yes, as far as the right of these 43,000 people whose services were, regularized, provincialized, if they assail it or do something, file review, that's a different thing. But it will not, my lord, bind the other parties who were not before the court.
That we agree.
That is how I think we should proceed.
We agree with that.
Yes. If that is the position, my lord, now let us see what is the law on deemed provincialization right.
All right.
Yes, de facto doctrine. De facto doctrine. De facto doctrine. De facto doctrine saves the actions taken. So, my lord, there was no requirement of this para
Correct,
18.
correct, correct. There are decisions of the Supreme Court.
Yes. De facto doctrine. So, my lord, basically, the law, as I have understood, with regard to, my lord, saving or preserving of right under the repeal act is mere hope and expectation will not do, and some positive act must be done pursuant to that. And most importantly, my lord, there is no requirement that on the day when the law was repealed or the new law came into being, any legal proceeding was pending.
So
Now,
what was the more that was done in this case for the petitioners?
My lord, in this case, what had happened, as far as the petitioners and other, including 32,000 teachers, teaching and non-teaching staff were concerned, their cases were considered by the district level and state level committee. In the final phase, my lord, the order was to be issued. The understanding was it will be done in a phased manner. That is how, my lord, the act was struck down. Therefore, everything was in limbo. De facto doctrine. Please, this Anna. From 54 to the home. Lord, first decision which I would like to place is that 1953, na?
So according to you, Mr. Chaudhary,
Yes, my lord.
N4 was complete in terms of earlier.
Yes. Itu কোনটো আছিল? No more. Wait. De facto doctrine. 55. Mohar Singh. My lord will first have AR 1955 SC.
Yes.
Google hai? Do nahi. What if I go to Right. My lord, the state of Punjab versus Mohar Singh, AIR 1955, Supreme Court 84. Paragraph 8. আজিকালি কিবা এটা হৈছে একদম পাহৰি যদি 10-15 মিনিট মনত নপৰে। Hello, paragraph 8, the sentence starting with the High Court in support of the view it took.
Yes.
Lordships got it?
Yes, please.
Yes, no, I don't, this is a very big paragraph. I'll have your Lordship's kind attention towards the later part of para 8. The
Yes.
sentence starting with, but when repeal is followed by fresh legislation, line about 10 or 12 of from bottom of para 8. But when repeal is followed by fresh legislation on the subject,
Yes.
but when repeal is followed by fresh legislation on the same subject, we would undoubtedly have to look to the provisions of the new act, but only for the purpose of determining whether they indicate a different intention. The line of inquiry would be not whether the new act expressly keeps alive all rights and liabilities, but whether it manifests an intention to destroy them. We cannot therefore subscribe to the broad proposition that Section 6 of the General Clauses Act is ruled out when there is a repeal of an enactment followed by fresh legislation. Section 6 would be applicable in such cases also, unless the new legislation manifests an intention incompatible with or contrary to the provisions of this section. Such incompatibility would have to be ascertained from consideration of all relevant provisions of the new law, and mere absence of a savings clause by itself is not material. It is in the light of these principles that now we proceed to examine the facts. So, my lord, the principle of law which has been laid down in my humble understanding is, in a given case, there may not be a repealing or savings clause. Or even if there is, then Section 6 of the General Clauses Act will still continue to hold the field. There, the dominant intention which to be gathered is whether there is an intention to destroy the right which was earlier there in the old act. Now, in the instant case, Lordships will find Section 4 of the 17 Act also prescribes a similar prescription of deemed provincialization. Only thing is, my lord, now they're insisting on some additional requirement. So, my lord, the intention to take away the deemed right is not there. The deemed right of provincialization still continues on this. That legal regime still continues in the old new act. Only rider is some additional condition is being prescribed. Even otherwise, if we read the scheme of the whole act, we don't find any intention whereby the what was prescribed in the 2011 Act is sought to be taken away. Now they say, in view of some additional qualification which is prescribed by NCT or others, those qualifications should also be there. Anyway, that argument would be relevant when we talk of the case of teacher and tutor. So, my lord, my humble submission is it's not a case where the intention is manifest, which shows that the deemed provincialization, an aspect which was there in the 2011 Act, is sought to be taken. It is still there. Therefore, it cannot be said that the 17 Act does not prescribe a similar prescription. Next, my lord will have 59. My lord, these judgments I have already relied on the other day. This is P.D. Agarwal, then Tushar Ranjan Mohanty, and J.S. Yadav. While open, so I will not repeat those. I have already given those. Yes. Now, my lord will kindly come to 1981 SCC 149. This is on the aspect of the deemed right. 1981 SCC 149. 1981 SCC 149. I'll rely upon para 12 to 16. Defacto doctrine.
Yes.
In considering the effect of an expiration of a temporary act, it would be unsafe to lay down any inflexible rule. It certainly requires very clear and unmistakable language in the subsequent act of the legislature to revive or recreate an expired right. Oh, para 12 to 16. In considering the effect of an expiration of a temporary act, it would be unsafe to lay down any inflexible rule. It certainly requires very clear and unmistakable language in the subsequent act of the legislature to revive or recreate an expired right. If, however, the right created by the statute is of an enduring character and is vested in the person, that right cannot be taken away because statute by which it was created has expired. In order to see whether the rights and liabilities under repeal ordinance have been put to end by the act, the line of inquiry would not be whether, in the words of Mukherjee J. in so-and-so, the new act expressly keeps alive the rights and liabilities under the repeal ordinance, but whether it manifests an intention to destroy them. The same principle in 255. Another line of approach may be to see how far the new act is retrospective in operation. It is settled both on principle and authority that the mere right existing under the repealed ordinance to take advantage of the provisions of the repealed ordinance is not a right accrued. Subsection 2 of Section 31 of the Act was not intended to preserve abstract rights conferred by the repealed ordinance. The legislature had the competence to restructure the ordinance as to meet the exigencies of the situation obtaining after taking over the contract carriage service. It could reenact the ordinance according to its original term or amend or alter its provision. What were the things done, action taken under the repeal ordinance? The High Court rightly observed there was neither anything done nor action taken. Therefore, the petitioners did not acquire any right to absorption under Sub-Rule 3 of 2020. The employment of the former contract carriers operators in normal course filed in the pro forma giving their service particulars and reported to duty. This was in the mere hope or expectation of acquiring a right. The submission of these call reports by the employees did not subject the corporation to a corresponding statutory obligation to absorb them in service. As a matter of fact, nothing was done while the ordinance was in force. The Act was published on March 12, 1976. On May 29, 1976, the corporation sent up the proposal for equation of post to be filled up in by the employees of the former contract carriage operators. The meeting of the committee set up by government for laying down the principles for equation of post and for determination of interstate seniority met on June 2, 1976. The committee decided that even in the case of helpers cleaner, there should be a trade test and the staff cleared by the committee for the post of helper B&A and assistant artisans should be on the basis of their technical competence, experience, ability, etc. The committee also decided that all other employees of the contract carriers operators were eligible for absorption should be interviewed by that committee for the purpose of absorption on the basis of experience, ability, duties, and responsibilities. These norms were not laid down till June 2, 1976. Till their actual absorption, the employees of the Artswell contract carriers operators had only an inchoate right. Now, this is important. The distinction between what is and what is not a right preserved by the provisions of Section 6 of the General Clauses Act is often one of great fineness. What is unaffected by repeal of a statute is a right acquired or right accrued under it, and not mere a hope or expectation of a liberty to apply for acquiring a right. Then, Lord, may skip this, please come to para 16. Further, it is significant to notice that the savings clause that we are considering in section 31(2)(I) of the Act saved things done while the ordinance was in force. It does not purport to preserve a right acquired under the repeal ordinances. It is unlike the usual saving clauses which preserve unaffected by repeal not only things done or the repeal enactment, but also the rights acquired thereunder. It is also clear that even section 6 of the General Clauses Act, applicability of which is excluded, is not intended to preserve abstract right conferred by repealed ordinance. It only applies to specific right given to an individual upon happening of one or other of the events specified in the statute. Now, in this case, my lord, the case of 32,000 persons, including the petitioners, were processed. Those are pending finalization by the government. So therefore, a positive act was done by the government towards provincialization of service of the petitioners who were before your lordships. Therefore, their litigation need not be pending before the court on the day when the new act came into force. All that is required is also from the other judgments, some positive act. Now, here in this case, my lord, nothing was done. So therefore, Honorable Supreme Court says it cannot be saved because some positive acts are required. Consider question again, positive act. Now, my lord will kindly take 1989 2 SCC 557, 1989 2 SCC 557. Bansidhar versus State of Rajasthan. I'll rely upon paragraph 34 and 37, no, para 30, 34 and 37. Now, in many judgments, Supreme Court has used the word inchoate one. It should not be an abstract. If it is an enduring, if it is not inchoate, then it will. Please come to page 570, para 30. Whether lordship got the judgment?
Yes.
Please come to page 570, para 30. For the purpose of these clauses, the right must be accrued and not merely in an inchoate one. The distinction between what is and what is not a right preserved by section 6 of the General Clauses Act, it is said, is often one of great fineness. What is unaffected by repeal is a right acquired accrued under the repeal statute and not a mere hope or expectation of acquiring a right or liberty to apply for a right. And losses may kindly skip over to para 34. The rights and obligations under this provision had to be determined with reference to the notified date, that is 1st of April 66. The scheme of the Act seems to be to determine the selling area of each person with reference to the appointed day. The policy of the Act appears to be that on and after the appointed day, no person in the state should be permitted to hold any land in excess of the ceiling area as determined under the Act, and ceiling area would be that which is determined as on the appointed day. So, my lord, what would be the ceiling area? Would be one which is prevailing on the date of appointed date, that is 1st of April 1966. Now, please come to page 573, para 37. It is therefore seen that the right of the state to take over excess land vested in it as on the appointed day, and only quantification remain to be worked out. Now, in this case, what had happened, quantification was not done. Otherwise, by operation of law, appointed there, if somebody is holding more than the ceiling limit, then the land vests with the government. What was left to be done was quantification. Now, in this circumstance, what Supreme Court had to say? It may therefore that under the some repeal enactment, a right has been given, but that in respect of it, some investigation or legal proceeding is necessary. They're referring to the judgment of my Lord, House of the Lords. The right is then unaffected and preserved. It will be preserved even if a process of quantification is necessary. But there is a manifest distinction between an investigation in respect of a right and investigation and an investigation which is to decide whether some right should be or should not be given. On a repeal, the former is preserved by Interpretation Act, like General Clauses Act. Para 39. We agree with the High Court, right of the state to the excess land was not merely an inchoate right, but under the Act, but a right accrued within the meaning of Section 6C of the Rajasthan General Clauses Act, and liability of the landowner to surrender excess land as on April 1, 1966 was a liability incurred. Also within the meaning of the said provision, there is no substance in the contention B. My Lord will kindly apply in a reverse case. Supposing Lordship is trying to find out whether a liability has been incurred under an my Lord repealed act. That will balance the my Lord question. Now here in this case, on the passing of the act, there was already appointed date. That is 1st of April of 1966. It's a fact on that day, the right of the government to access land already stood, my Lord, declared. What was not done was, my Lord, quantification. Whether from somebody 10 bigha will go, 20 bigha will go, so and so forth. Similarly, in our case, my Lord, our proposals are there. Only thing that is required to be given was a finality to that recommendation. So in that situation, whether it can be construed that the deemed right has crystallized to the status of a my Lord vested and accrued right, so that any repeal cannot take away or such. Now, my Lord, the next judgment is 1999, 9 SCC 334. It's very interesting, my Lord. It was in the context of Arbitration Act.
Yes.
Now, please come to para 28. Now, there was an award under the old Act, RTE Act. Now, a question arose regarding execution. Section 85(2)(a) is the saving clause. It exempts old Act from complete obliteration so far as pending arbitration proceedings are concerned. That would include savings of whole of the old Act, but till time of the enforcement of the award. Thus, Section 85(2)(a) prevents the accrued right under the old Act from being affected. Saving provision preserves the existing right accrued under the old Act. There is a presumption that legislature does not intend to limit or take away vested right unless language clearly points to the contrary. It is correct that the new Act is a remedial statute and therefore Section 85(2)(a) calls for a strict construction, it being a repealing provision. But then, as stated above, where one interpretation would produce an unjust or inconvenient result and another would not have those effects, there is then also a presumption in favor of the latter. For enforcement of the award, therefore, has to be examined on the touchstone of the proceedings held under the old Act. Various decisions have been cited before us to show as to what is the mere right and what is right accrued or acquired. We have to examine this question with reference to the provisions of Section 6 of the General Clauses Act, if it could be said that when the arbitral proceedings have commenced under the old Act, a party has acquired a right to have the award given, thereafter enforced under the old act. Question that arises for consideration is, if a right has accrued to the party or it is merely an inchoate right. Three cases referred, namely so-and-so, 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 shows that something more is required for vested right to accrue. Right did exist, but then nothing was done to show that any act was done or advantage taken of enactment under which the right existed till it was repealed. An act gave the right and new act which repealed the old act took away that right. Mere right to take advantage of provisions of an act is not a right accrued. In CIT versus so-and-so, this court said that the right which had accrued and had become vested continued to be capable of being enforced, notwithstanding the repeal of the statute under which the right accrued, unless repealing statute took away such right expressly or by necessary implication. In the case of Bansidhar versus Rajasthan, this court had said what is unaffected by repeal is the right acquired or accrued under the repeal statute, not mere hope, expectation of acquiring a right, etc., etc. A provision to preserve right accrued under the Repeal Act was not intended to preserve abstract right conferred by the Repeal Act. It implies to specific rights given to an individual upon happening of one or more other events specified in the statute. This is very important in my humble submission. We think the observation of Lord Morris in so-and-so are quite apt, which have been quoted elsewhere in the judgment. In Sivananda, this court again said that if right created by the statute is of an enduring character and is vested in the person, right cannot be taken away because statute by which it was created has expired. Then my lord will kindly skip over. This court, the court held that in spite of repeal of section 11, the tenant had acquired the right to claim compensation in as much as notice to quit was given to him when section 11 was of the old act was in operation. In Gazraj versus State Transport Authority, this court said that some positive act is required to be done for right to accrue under the enactment which is repealed. I'll place that also. In this case, reference was made to a decision of this court in Gujarat State Electricity Board, where court had pointed out that before section 71 of the Act 40 was amended, the appellant had issued a notice under section 11. Therefore, exercising the option to purchase the undertaking, it was held that the right to purchase the electrical undertaking which had accrued to Electricity Board was saved by section 6 of the General Clauses Act. The principles enunciated in the judgment shows as to when a right accrues to a party under the Repeal Act, it is not necessary that for the right to accrue, legal proceedings must be pending when the new act comes into force. Now, I'll place these two judgments, this Gazraj and my lord Santilal, then the my lord things should be clear. দুটা বজাত হেৰি হ'ব নেকি এডাল কেছ আছে নেকি হা কোনে ক'লে I do. Gujarat. My lord, next is 1969 SC 239. 1969 SC 239. Para 15. The sentence starting with, it was next contended, para 15. It was next contended on behalf of the respondent that by the time the license period expired, section 7 of the Act had been amended and section 71 of the Electricity Supply Act repealed. No provision was made to preserve the rights already acquired under those provisions. Hence, the appellant is not entitled to purchase the undertaking. It is not the case of the respondents that either expressly or by necessary implication, the new law had taken away the right acquired earlier. That being so, Section 6 of the General Clauses Act comes to the aid of the appellant. This section provides that where that act or any central act or regulation made after commencement of that act repeals an enactment hitherto made or hereinafter to be made, then unless a different intention appears, repeal shall not affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repeal. It also saves the previous operation of any enactment so repeal or anything done, duly done or suffered thereunder. The right to purchase the respondent's undertaking came to vest firstly in the Bombay State Electricity Board, subsequently in the appellant in view of the various notifications referred to earlier. That right has to be worked on the basis of law as it stood on the date when the notice under Section 7(4) of the Act was given. In this court, a new contention was taken on behalf of the respondent, namely that in any case, appellant's right to purchase is a conditional on payment of the price as provided in Section 7, and hence the appellant cannot demand possession of the undertaking without paying the price after the same is determined in according to law. Contention had not been taken before the High Court. The High Court may get into the question while deciding the writ petition. Now, in this case also, my lord, the notice was given. That's why Honorable Court said that this will continue. So we resume at 2 o'clock.
Yes. Yes.
She needed to learn to bond this highway. কি বাকি থাকলে হোক বজরাজ সিং টু কি পজিটিভ একটা প্যারাগ্রাফ তো কিমান আছিল এটাই কপি না Lord, I think I last cited 1999 9 SCC.
Yes.
Now I'll place
No, you have cited 1969 SC 2239.
SR Desai, I think, 69239.
Yes.
That I have placed. Yes. Then Lord will kindly come to Gajraj Singh 1997 1 SCC 650. 1997 1 SCC 650. Just 2 paragraphs on facts. Please kindly note, my lord, para 2, 3 for the facts. Then para 8, what was the issue? Then para 14, where that non-obstante clause is there. Then para 22. '25. Then eventually para 32, 42 and 43. Please come to para 2 at page 656. In 1988, the appellant was granted a state carriage permit on Mirat Baraut Road under Section 47(3) of the MV Act. for a period of 3 years. The Motor Vehicle Act 1988 came into force with effect from 1/7/1989. The said permit was renewed under section 81 of the Act in 91 for a further period of 5 years. And second renewal was granted in 1995. Respondents 3 to 17 had applied under section 70 for grant of stage carriage permit under section 72 on Mirat so-and-so route, which intersects part of the route on which the appellant was operating his stage carriage. Despite objection raised by the appellant, STA granted permits to them on 23/11/92, which came to be challenged by the appellant in revision filed under section 90 before the appellate tribunal. The state questioned the appellant's locus standi under the preliminary objection. The renewal granted under section 81 to appellant was void. By order dated 9/8/95, the STAT upheld the preliminary objection and held that appellant has no locus standi to object the grant of permit to respondent. Since renewal of permit granted to appellant was not valid in law, as he had not got any new permit under the Act. The High Court in the impugned judgment made in writ petition had upheld the order of the STAT. This appeal by special leave. Sri Venugopal and a senior counsel for the appellant contended that the renewal of the permit of the appellant granted under repealed Act is a permit under the Act, and its operation was saved by section 2172A, read with subsection 4 thereof. Therefore, the second renewal granted under section 81 was valid in law. There was no need for the appellant to obtain a fresh permit under the Act, as the renewal is a continuation of the original permit, which is a vested right. The effect of the saving provision in section 2172A is to allow all the permits granted under Repeal Act to continue after renewal under the Act. So this was the provision and the contention. My Lord will kindly come to para 8. The question for consideration is whether holder of a stage carriage permit under the Repeal Act is required to obtain a fresh permit or a renewal of the permit as per the provisions of the Act. So this was the issue. Okay, the Lord will kindly come to para 14. This was the provision which, according to Mr. Venugopal, saved their rights. Section 217 repeals the existing law and provides savings from its operation. Subsection 1 specifically repeals section 4 of the Act of 39 and any law corresponding to that Act in force in the state before 1/7/89. Subsection 2 with a non-obstante clause provides certain savings as provided thereunder. Clause A of section 2172 provides that notwithstanding the repeal of Act 4 of 39 or any other analogous enactment in operation, any notification issued, rules, regulation made, order passed or notice issued, or any appointment or declaration made or exemption granted or any confiscation made or any penalty or fine imposed, any forfeiture, cancellation, or any other thing done or any other action taken under Repeal Act and enforced immediately before so-and-so, insofar as it is not inconsistent with the provisions of the Act, be deemed to have been issued, granted, or taken under the corresponding provisions of the new Act. So, my lord, this was the legal provision. Now, please come to para 22, where the aspect of legal fiction was considered. When an act is repealed, it must be considered except as to the transactions past and closed, as if it had never existed. The effect thereof is to obliterate the Act completely from the record of the Parliament, as if it had never been passed, it never existed, except for the purpose of those which were commenced, prosecuted, concluded while it was existing law. Well, I'll put emphasis on the word where commenced. the exercise in our case was commenced. Legal fiction is one which is not an actual reality and which the law recognizes and the court accepts as a reality. Therefore, in the case of a legal fiction, the court believes something to exist which in reality does not exist. It is nothing but a presumption of existence of a state of affair which is actually non-existent. The effect of such a legal fiction is that a position which otherwise would not obtain is deemed to obtain under the circumstances. Therefore, when section 2171 of the Act repeal, Act 4 of 39 with effect from so and so, the law in Act of 1939 effect came to be non-existent except as regards the transaction passed and closed or saved. Then Lord will kindly come to para 25. On savings of right acquired, the principles of statutory interpretation by G.P. Singh at page so and so, the learned author has stated that effect of clause C2E of section 6 of the General Clauses Act is speaking briefly to prevent the obliteration of a statute in spite of its repeal to keep intact rights acquired and accrued and liabilities incurred during its operation and permit continuance or institution of any legal proceedings or recourse to any remedy which may have been available before the repeal for the enactment of such liability. At page 418, the learned author has stated that the privilege to get an extension of a license under an enactment is not an accrued right, and no application can be filed after repeal of the enactment. See so and so. In legislation and interpretation by Jagdish Swarup, it is stated that power to take advantage of an enactment may without impropriety be termed as a right, but question is whether it is a right accrued. A mere right, assuming it is to be properly so-called, existing in the members of the community or any one of them to take advantage of an amendment without any act done by an individual towards availing of that right cannot be properly to be a deemed right. Anyway, my lord, now all these cases I have played. So therefore, the basic requirement is that some act must be done in pursuance of the repeal law in respect of which this right is claimed. If some positive acts are done, then it will be definitely a vested and accrued right. Now, please come to para 32. It is already seen that operation of subsection 1 of section 217 is to obliterate Act 4 of 39 and any corresponding law in force in any state from the operation with effect from 1789. However, repeal shall not affect any right or liability acquired, accrued or incurred. Subsection 2 enumerates and saves from the obliteration of the Act 4 of 39 and corresponding law by fiction with its non-obstante clause. Then eventually, my lord, paragraph 42 and 43. There is a distinction between right acquired or accrued and privilege, hope, and expectation to get a right, as rightly pointed out by the High Court in the impugned judgment. A right to apply for renewal and to get a favorable order would not be deemed to be a right accrued unless some positive acts are done before repeal of the Act or corresponding law to secure the right of renewal. So Gujarat and all these cases are referred. So if no action under the Repeal Act was set in motion before 1789 by a valid application or renewal of a permit, there was no right acquired or accrued to pursue the remedy under the Act. The privilege to obtain renewal of a permit is not an accrued right. Section 58(2) of the Repeal Act give as stated supra, preferential right to a holder of the permit or renewal thereof. Section 71 of the gives preferential right in favor of so and so, so and so. So, my lord, the principle of law, which is deducible from all the judgments which I placed, is, my lord, basically section 6C2E, it does not obliterate the right which is acquired or vested under the old act. Rather, it saves. Now, in what manner, when it can be said that that right is saved? Some action must be taken, some positive action must be taken in furtherance of that provision towards realization of the objective. If it is not done, then it will be an inchoate right. The expression which has been used in so many judgments. It will not be an enduring right. It will be only an abstract right. Therefore, my humble submission, my lord, I mean, on this point, to eventually to sum up is, Section 4 read with Section 2H of the Act of 2011 envisages a deeming provision, meaning thereby, on the day when the Act of 2011 came into force, provided we fulfill the conditions enumerated in Section 4, then our services are deemed to be provincialized. Only thing is, some ministerial acts were left to be done. Now, those ministerial acts, what is that? The recommendation of the district level and state level committee were not given a final call by the competent authority. Otherwise, everything was done. Therefore, with the repeal of the act, that right cannot be said that it is evaporated. It subsists. If no action would have been taken, perhaps my argument would not have held any water. Now, my lord, only different, moreover, more pertinently, Section 4 of the 2017 Act also provides a similar provision. Only thing is now, they have come up with some more additional requirements. Now, therefore, what is required to be seen in the context of the law laid down by the Supreme Court, whether there is any manifest intention in the Act of 2017 to take away that right. If that intention does not exist, then lordships will have to record a finding in favor of the petitioners. So that is my humble submission as regards the lord deemed right. And another aspect which I would like to submit for lordship's kind consideration is, then my lord, let us test it from the side of a liability. Supposing a liability is incurred under the Act. Now, are the arguments which the state will now take will be available to them? End of the day, whether it is a right accrued or liability incurred, it's the same thing. So when it comes to whether I have committed an offense under the repealed act, the test would naturally be the same. So therefore, when we balance both, what follows is there is a right which needs to be recognized. So this is my submission. The only thing is, my lord, here, the new condition which has been imposed is under Roman 4 is that we need to, that minimum number of students in the school must be 10 or something. Then only then we can be. That's otherwise we fulfill everything. Like qualification of the problem now. So that is the only. That is, let me point on even this. I love the Act starts at page 99. It is a Roman 4 at a hill to code. Section 4 or something.
Page 115.
Right. Thank you. My lord, the 4(2) clause 4 at page 115. In case of teachers and or tutors of the schools for special subject like Sanskrit, Arabic, Hindi, we are craft teacher, a music teacher and other classical teacher, the number of students appeared in the concerned final examination like HSLC, HS 10+2 conducted by SEBA or Assam State Higher Secondary Education Council, as the case may be, shall not be 10 students in each class per year during the last 3 years. So this is the additional requirement which has now been envisaged. Otherwise, my lord, there is no other reason why our cases cannot be considered under the 2017 Act. Another aspect which needs to be gone into is when a venture institution is set up, these people actually may not contribute. End of the day, today, the government institutions are not doing good. Something must be wrong drastically somewhere. The state has to take a call. Now it is if we think of maybe 30 years back, it is the same government school products who have gone to these very high heights in life. People have gone to IITs, people have gone abroad. So something that's a different issue. Otherwise, these teachers of these venture education institutions, they have sacrificed a lot also. That cannot be, my lord, obliterated altogether. That cannot be, just brushed aside. End of the day, they struggle. Only towards the end of their life, they get some benefit. So that also needs to be taken note of. Yes, now there is a requirement of overhauling the system so that end of the day, government institutions also can be compete with par with the private institutions. There, my lord, where the government's effort has to be there. So many things are there. Anyway, that is not an issue. But then that is an aspect which perhaps lordships will consider. Otherwise, my lord, these people are working for the last 12 to 26 years. Now, where do they go? So therefore, a liberal, a purposive interpretation has to be given towards realization of the objectives. Otherwise, my lord, it will be very difficult. End of the day, why these courts in India have developed this purposive interpretation principle? Idea is to realization of the
Motilal Padampat.
No, there are so many other decisions. Motilal Padampat was in the context of promissory estoppel. On purposive interpretation, other decisions are there. So this is regarding this craft teacher.
Perhaps that MP Sugar Mill case is also.
MP Sugar Mill is that Motilal Padampat. MP Sugar Motilal Padampat. And my lord, the other day I was trying to indicate this judgment. Now that I was talking about that Manish Kumar, the grounds of judicial review. Now, my lord, once these benefits are not given, then it will also entail violation of Article 14 and 16. Manish Kumar to give. Yes. 2021 5 SCC, phase 1. My lord will kindly come to page 1, para 56 at page 60. I'll rely upon para 56 and 60.
Yes.
Page 60. The grounds on which plenary law can be challenged are well established. In the first 2 decades, decision of this court unerringly point to 3 grounds which render legislation vulnerable. A law can be successfully challenged if, contrary to the division of power, either parliament or the state legislature usurps the power that does not fall within its domain, thus rendering it incompetent to make such a law. Secondly, a law made contravening fundamental rights guaranteed as a part 3 of the Constitution could be vitiated with unconstitutionality and declared void to the extent of its contravention. Needless to say, law within the meaning of Article 19 of the Constitution would remain valid qua non-citizen. Thirdly, apart from fundamental right, the supremacy of the Constitution vis-a-vis ordinary legislation, even when the law is plenary legislation, is preserved with a view that legislation must be in conformity with other provisions of the Constitution. Basically, my lord, Article 254. Then, my lord, will kindly come to paragraph 60. This view, namely that be it a plenary law, if it is found to be manifestly arbitrary, it becomes vulnerable, has been followed in the following decisions amongst others: Naftes, Joseph Saini, K.S. Putuswamy, Hindustan Construction. So this is a ground which in the recent judgments, my lord, has been developed, including in Shreya Singhal's case. So if there is a manifest arbitrariness, then also a legislation can be questioned. Well, regarding that de facto doctrine, can I place that judgment? Yes. 1981, 3 SCC, page 132. My lord, I'll just coming to para 18, which sums up the legal position. Para 18. Para 18.
You're referring to 1981.
Yes, 1981, 3 SCC, page number 132. Judges level bench. Please come to page 141, my lord. Para 18. We do not agree with the submission of the learned counsel that the de facto doctrine is subject to limitation, that the defect in the title of the judge to the office should not be one traceable to violation of the constitutional provision. The contravention of a constitutional provision may invalidate an appointment, but we are not concerned with that. We are concerned with the effect of invalidation upon the acts done by the judge whose appointment has been invalidated. The de facto doctrine saves such acts. The de facto doctrine is not a stranger to the Constitution or to the Parliament and the legislature of the states. Article 71(2) of the Constitution provides that acts done by the President or Vice President of India in exercise and performance of powers and duties of his office shall not be invalidated by reason of election of a person as President or Vice President being declared void. So also Section 1072 of the Representations of the People Act provides that acts done and proceedings in which a person had participated as a member of the Parliament or a member of the legislature of a state shall not be invalidated by reason of election of such person being declared to be void. There are innumerable other parliamentary and state legislative enactments which are replete with such provision. The 20th Amendment of the Constitution is an instance where the de facto doctrine was applied by the constituent body to remove any suspicion or taint of illegality or invalidity that may be argued to have attached itself to the judgment, decrees, sentence, or orders passed or made by certain district judges appointed before so and so. Otherwise, then in accordance with provisions of Article 233 and 235 of the Constitution. The 20th Amendment was consequence of the decision of the Supreme Court in so and so that appointment of district judges made otherwise than in accordance with provisions of so and so were invalid. As such, appointments made in many states in order to preempt mushroom litigation springing up all over the country, it was apparently thought desirable that precise positions should be stated by the constituent body by amending the constitution. Sri so-and-so learned counsel for the appellant argued that constituent body could not be imputed with intention of making superfluous amendments to the constitution. Sri so-and-so invited us to say that it was necessary inference from the 20th amendment of the constitution. But for the amendment, the judgment degree of the degree of the judges appointment otherwise than in accordance would be void. We do not think that the inference suggested by Mr. Fatke is a necessary inference. It is true that as a general rule, the parliament may be presumed not to make a superfluous legislation. The presumption is not strong presumption, and statutes are full of provision introduced because of abundant caution. There is no harm in me being cautious. When judicial pronouncements have already declared the law on the subject, the statutory reiteration of law with reference to a particular case does not lead to necessary inference that the law declared by the judicial pronouncement ought not to apply to particular cases, but may also lead to inference that statute-making body was mindful of real state of law, but was acting under influence of excessive caution. And so, to silence the voices of doubting Thomases by declaring law declared by the judicial pronouncements to be applicable also to a particular case. In Chandramohan, this court had held appointment of district judges made otherwise than in accordance with Article 233 of the Constitution invalid. Such appointment had been made in Uttar Pradesh and few other states. Doubts had been cast upon the validity of the judgment, decrees, etc. pronounced by those district judges, and large litigation had cropped up. It was to clear those doubts and not to alter the law that the 20th amendment of the Constitution has made. This is clear from this so-and-so. So, my lord, para 19, in our view, the de facto doctrine furnishes an answer to the submission of Fatke based on section 9 of the CRPC and 21 of the Constitution. So basically, my lord, de facto doctrine takes care of the actions or validates the action taken by authority who is not competent. So therefore, my lord, in that view of the matter, in my humble submission, the concern which had been shown by the division bench in para 18 and the consequential direction which was given in para 19 was perhaps, my lord, in my humble submission, was not called. It was not really required. So therefore, lordships will not be guided by the observations made therein to determine the entitlement of the right of the present bench of petitioner. If yes, of course, my lord, qua those 42,000 odd people whose services were, of course, that will have some relevance. It's not my submission.
But we are not concerned with
Yes, we are not concerned with that. They are not before your lordships. Now, my lord, in the other two cases, this is my submission as far as this particular case is concerned. I also tried to find out what is the exact scope and purport of a repealing and savings clause. In so many words, in black and white, we could not find. But what is seen is, my lord, so on repeal of an act, whether legislature desires to save any action of the under the law which was taken when the law was not repealed. But then in so many judgments says, my lord, whether it is there or not there.
No, but in this case, the law was not repealed. It was struck down by.
Yes, struck down. My lord, next group of cases, group 13. Move copy to. Right, the thing will like interrelation. Is it in there? So move Oshima thing will like it. Hey, Rajesh. I now Program not will group 13. My lord, I'll read only the facts, otherwise, and one or two submission on the merits. The common thread among all the cases are that deemed provincialization. Additionally, there are 2-3 points.
So in the group 13, 3-1, Roman 11.
Yes. No, my lord, I am not appearing in those cases where I am not, my clients are not aggrieved by that cutoff date. So therefore, I am not in that series. I do not have any submission. Now, here in this case, I have just one paragraph, my lord, for the facts. All the petitioners are serving as assistant teachers in their respective schools, following their appointment made by the managing committee of the school before 1/1/2011. All the petitioners teach Assamese, English, Hindi, Bengali, Arabic, and social studies. After repeal of the erstwhile Act of 2011, as the Act of 2017 was enacted amongst others to provincialize the services of the teachers of the venture education institution and to recognize and streamline the educational institutions up to degree level. As per Section 3(1)(11) of the Act, there shall be the minimum 3 numbers of tutors, teachers or tutors of whom at least 1 teachers for a science and mathematics, B, social studies, and C, language. Proviso to Section 3(1)(11) provides for additional posts in accordance with the norms and standard stipulated in Right of Children to Free and Compulsory Education Act 2009. That services of the petitioners who are identically placed, like that of the petitioners, their services were provincialized under the Act of 2011. Similarly, under the Act of 2017, services of teachers who are identically placed as the petitioners have been provincialized by the state respondents. The petitioners understand that their services have not been provincialized because as per Section 3(1)(11) of the Act, services of 3 teachers can be provincialized and the petitioners do not come under the ambit of 3 teachers. Section 6 of the Act provides that the services of the teacher of venture upper primary school shall be considered for provincialization, subject to fulfillment of eligibility criteria relating to educational professional qualification as laid down under the Act of 2009. The minimum qualification for a person to be eligible for appointment as a teacher in elementary school prescribed by NCTE by notification dated so and so, which came into force with effect from 3/9/2001. Incidentally, some of the petitioners were appointed before 3/9/2001. As per clause 4 of the notification dated 23/8/2010, teachers appointed before issuance of the notifications are not required to acquire the minimum qualifications specified in para 1 thereof. In the case in hand, all the petitioners were appointed prior to 23/8/2010. Thus, prescription in so and so is not in conflict, is in conflict with the notification dated so and so. So, the notification says whosoever were appointed before 23/8/2010, they did not have this qualification. Whereas the Section 3(1) says it would be required for provincialization. So these are the facts. Now, my lord will kindly take the Act for a moment. Oh, before the petition contest. Before that, I'd just like to.
Copy of this notification is there in the petition?
Yes.
What is the page number?
Yes. Page 94. And the notification is at page number 92. New Delhi, 23rd August 2010. In exercise of the power conferred by subsection 1 of section 23 of the Right of Children to Free and Compulsory Education, and in pursuance of the notification dated 31st of March 2010, issued by Department of School Education, so and so, hereby lays down the following minimum qualification for a person to be eligible for appointment as a teacher in class 1 to 8 in school referred to in clause N of section 2 of so and so. My lord will kindly come to page 94, clause 4. Teachers appointed before the date of this notification The following categories of teachers appointed for class 1 to 8 prior to the date of this notification need not acquire the minimum qualification prescribed in para 1 above. Then please come to C, my lord. A teacher appointed before 3/9/2001 in accordance with the prevalent recruitment rules. If I am appointed before 3/9/2001, then it will be in accordance with the recruitment rules. This notification will not apply. Now, my lord, I will not trouble your lordships on that 3 teachers ground. I think my senior colleague, Mr. B.C. Das, has already argued. I adopt that argument, my lord. I don't, find it necessary to add anything. So in this case, therefore, in my humble submission, those who were appointed prior to 3/9/2001, in their case, the question of applying this and denying them the right of provincialization is otherwise should not be a subject of this division bench. But then since other point is involved, therefore we are together. So, my lord, all the grounds of legal grounds also, whatever we have taken, we have already taken. So I will not trouble your lordships. Itudia.
So, Mr. Chaudhary, you conclude?
Yes, one more, my lord. I'll just take 5 minutes, my lord. There is one more case, item number, it's a group 19. Yes. My lord, in fact, these teachers are working for 20 to 25 years. Here, my only point is, we have been appointed as tutor. Now, my lord, the objective which is sought to be achieved by the Act is, the services of these teachers who are working in venture schools is to be provincialized. Now, I can appreciate, my lord, on the basis of qualification, at least for career progression of a service personnel, it is possible, it is permissible to prescribe a higher qualification. There is an innumerable Supreme Court decision where Supreme Court says, if a class is created for climbing the ladder in the service career, then it is permissible. But when it comes to entry level, because somebody is holding some higher position, he may get some additional increment, he may get a higher pay scale. But those who are not equipped with those additional qualification, they may not get equal pay. But end of the day, both are mandated to teach. When both are mandated to teach, can we come up with that concept called tutor? Well, it's not a question of doling out, state largesse in this manner. End of the day, my lord, it's a welfare state. Under Article 39 and 43, there is a corresponding duty on the part of the state. If I am not having a particular qualification, then I may be entitled to a lesser pay scale. But my lord, I am a government, sir. My services has been provincialized, means from that day onwards, I am part and parcel of the government. That means, my lord, I am a public servant. I am a government servant. I am holding a civil post. In independent India, where have we come across, my lord, fixed pay for a civil servant? It is unheard of. It is unheard of. That's why I say, my lord, it is manifestly arbitrary. This classification suffers from the vice of manifest discrimination. I appreciate somebody is having master degree, somebody is having, some professional qualification. Make them eligible for higher pay scale. Make them teach in higher classes. But end of the day, how can you make this classification of teacher and
So they will not be entitled to any pension.
and nothing, only 18,000 rupees all throughout my life. No promotion, no nothing. It's unheard of, beloved. So this is the case about treating us as tutors because we lack certain, anyway, if I succeed in my first point, then lordship need not go to all this. But then additionally, I'm making it clear. So my point of view,
So they are not graduates.
they're graduates. They're not having those perhaps that professional called like BA, something, TAT, and all these things.
5 years time. 5 years time has been.
My lord.
5 years time is given to them.
Otherwise given.
So if I will become BA, then this.
Then they will corresponding to this, the teacher whatsoever they will do. Even the headmaster will be.
In fact, my lord, under section 26 of that 2009 Act, those provincial section, just section 26, na?
You know?
It's a 5 বছর দিয়ে দেয়। Degree পাবার কারণে। NCT হয় দিয়া। NCT 3 নে 6?
কি হয়? এই provincialization?
এই যে degree বিলাক পাবার কারণে যে PS
আচ্ছা। ইয়াতে দিয়ে
23 নে 26?
ইয়াতে দিয়ে আছে।
NCT 23 নে 26 আছে।
সেইটো শেষ হ'ল, পুস্তকত শেষ হ'ল।
শেষ হ'ল।
19ত।
Yes.
So that is our humble submission.
All right, you say arguments of the writ petitions are complete. Day after tomorrow, is it? Mr. R. Majumdar, Learned Standing Council Education Department. Submit due to some personal difficulty. The learned advocate general Assam will address the court in this batch of writ petition. He is unavailable today. Therefore, the matter is posted on any other convenient day as may be deemed fit on any other convenient day by this court. Taking note of the request made by Mr. Majumdar, these writ petitions are directed to be posted again day after tomorrow, that is the date, for further hearing as fixed matter.
My lord,
Next item.
Publish.
my lord, item number 61, my lord, similar, exactly similar with my senior, my lord, item number 15, my lord. So I pray for, my lord, taking together this matter.
Sorry?
I pray for taking together, my lord. I will adopt the submission of my senior.
Second point.
Please tell him that we would like to make an attempt to make some progress.
Yes, we have
So,
informed.
Mr. Majumdar, we wanted to know about a few things.
My lord.
This RTE Act came in 2009, right? And as it appears, 2011 Act was triggered by the requirements in RTE Act and the rules framed by the state. The state wanted to streamline the educational institutions itself. But there is a history in the state prior to 2009 as well.
Yes.
There were a number of venture schools, colleges. Those were governed by different statutes. These statutes are still holding the field. There are rights conferred under those statutes. The Act of 2017, or for that matter 2011, does not subsume those acts. Does not subsume. No argument has been addressed by the petitioners on that count. But we will definitely look into it because as it was observed by the division bench in the earlier round, since we are going into the matter, we'll go into it holistically. Because piecemeal plucking things
Will
here
not
and there does not help. So as you have noted, the bulk of the argument is that if you want to streamline and kind of take care of the provincialization process with a view to stop further mushrooming, then why have you created two different classes by announcing a date of 1/1/2006 as a, then having done it, they are also merely because there is delay in the ministerial action, you have eliminated a large number of people. And then you have totally obliterated many category of teachers without any valid reason. For example, Hindi teachers, Arabic teachers, they are never going to be, almost never going to be provincialized. These are some of the arguments where you will have to address, please brief the general on that. Are you provincializing more teachers now?
No.
Some posts
Yes,
have
sir.
been created recently.
Well,
32,000.
those are which were already under consideration. If there was some problem in their provincialization, maybe a court case, maybe something, whatever went
No,
wrong.
no, when the Act of 2011 was set aside,
Yes.
some 75 odd thousand teachers
Hmm.
were contenders of provincialization,
Yes.
with many of them having already been provincialized, around 45,000. And balance around 31,000 was left. These people are yet to be provincialized.
Yes.
Now, you have recently created more posts to provincialize teachers. Are you going to take in now new teachers?
Recently, I'll find out, but
You'll find out.
I'm not in the.
We are tech-savvy judges. You have to keep up with that. You better come prepared on that.
Yes.
We'd like to know what really is happening. Yesterday it was available. Whatever it is,
More
we want to know what it is. 32,000 posts of provincialized teachers have been retained. There has been retention,
Permanently retained.
permanently retained. Which are those
These-
32,000
the-
posts?
the-
Why they are
these-
permanently retained now?
These posts which were created for provincialization, those posts were created on supernumerary basis to the personal to the person concerned, the incumbent concerned, they die with
2,000.
die with the person concerned. Under the 2017 Act, perhaps when I'll have to go through it, but perhaps when the provincial and
We'll find
ordinance
out.
were made, this continuation was not there, the retention facility was
In
kept back.
addition to 42,000, another 32,000 to be retained permanently.
May I, Lordship? In fact, Lordship, in my case, Lordship, we have filed an additional affidavit there stating that in 2020, they have recruited 5,000 odd teachers in contract basis with a similar kind of qualification. They are not having BEds, they are having BA graduation, but like they don't have the additional qualification of the BEd and all. So that we have brought on the record.
That's
That we
another
will
thing.
put it.
This retention happened in